All right, to discuss today's signing of the BELA Bill, we're joined by education analyst Professor Mary Metcalfe. Afternoon, Professor. Thank you very much for joining us on the program. So the President has finally signed the bill, but resolved to delay the implementation of clauses 4 and 5. Your reaction to the President's decision just to approach that issue in this way?
It's an interesting approach. As he's indicated, the merit of doing so is to carry on building the conversation so that we achieve greater unanimity about the bill and its implementation. And I think that that is appropriate.
But one wonders then in what form, or this consultation, what form it will take, because it's 90 days. And he has indicated, even in that statement, that what he's looking for here now are solutions. So it's not an invitation for more people to register their concerns around clause 4 and 5, but he's looking to engage with people that will put solutions on the table. What would you think could possibly be the kind of solutions that would make sense now with just this period of 90 days?
Okay, so there's 3 things I think we need to talk about. One is what's going to happen in the 3 months. The status of the bill, which is now an act, who will participate, and then what are the likely outcomes? If I can maybe just take all of those ones. So he has signed the bill so that it is now an act. He's obliged to do that because the Constitution requires him to sign a bill that has been passed by Parliament, both houses of Parliament. He can only not sign it if it is unconstitutional. Now, that's a very interesting point, which I'll come back to. He's also determined that whilst he signed it, he's going to delay implementation until after 3 months, until there has been a process of consultation. Now, what does that mean? It means that we carry on with the existing legislation. After the 3 months, we proceed with the new act, because this replaces previous acts. When it replaces previous acts, there's 2 options that seem to me, or possibly 3, but let's keep it simple to 2, is that he will either have found a resolution to clauses 4 and 5, which we'll come back to, and then the whole bill is implemented, or if those clauses, no solution is found, the existing provisions of the existing legislation will guide us in respect of those 2 elements.
Now let's delve deeper then into clauses 4 and 5.
Okay, so there's, in the consultation process, both within the National Assembly as well as in COP, there were 2 main issues. I'll start with clause 4. In the National Council of Provinces, the Western Cape was the only province that did not support the adoption of the bill. And one of the issues that they raised is that the bill makes grade R compulsory. Grade R would be now making it compulsory for children to go to school in the year in which they turn 6, which is, they'll be 5 or 6 years old. The Western Cape was concerned about the costs of picking up the teacher salaries for grade R. The Treasury has estimated this to be in the region of about 17 billion annually, but remember that that's only 5% of the education budget. But the education budget is pressurized, and clearly this has challenges for the provinces as they prioritize. So that's why I think clause 5 has been earmarked for discussion. Clause 4.
Yes.
For clause 5, it would have both clauses would have to be not constitutional, I think, in order for it not to proceed. But we'll await for more sophisticated legal advice on that.
It seems the Minister, pardon me for interjecting there, but it seems the Minister of Basic Education, Sivuyo Harube, at least if we can go on what she stated in the statement she issued today, that she was concerned about the constitutionality of these specific clauses.
Yeah, so the constitutionality in terms of the grade R for me is interesting because we do not have a legal definition of what basic education means. And that is important because basic education is an immediately realizable right. And that would mean if basic education is from grade R to grade 9, which is 10 years, which is, I think, what is more or less the norm internationally on the continent, that would mean we know between the ages of 6 and 16, education is compulsory and we must prioritize that. Do you want to move to language clause 5?
Please let us move just in the interest of time, because it was also one of the very contentious ones. So language again, even we had the minister there saying it's quite concerning to her.
Yeah, so the language one, I think a resolution should be found because the Constitution is absolutely clear that all learners have the right to receive education in their language of choice. But it also has to be, we have to also look at effective access, we have to look at alternatives, it has to be practicable. Now, what clause 5 does is it says the school governing body has a right and a responsibility to take forward that injunction of the Constitution just as much as the provincial department does. In previous iterations of the law, it's been clear that the school governing body has a key role to play. What BELA does is it takes all of the subsequent court cases, which we must welcome because they add flesh to what does this mean. And what is clear from all the court cases is that the school governing body has got an important role to play. But if education is compulsory, it is also the responsibility of the education department to ensure that all available spaces in schools are used. So all court cases have given the primary responsibility to the state in public schools. What BELA does, I think, protects and guides school governing bodies because it lays out the detailed procedures that must be followed by the provincial education department if it wishes to engage a school governing body to say, for example, your school is underutilized. Can we not have a dual medium or a parallel medium school that would enable us to accommodate more learners within this public school?
Yes.
So it doesn't change anything in law as far as I'm concerned. It spells out the processes that must be followed. And because it's in law, it's reviewable. It means if an education official doesn't follow those procedures, the law, any court will look at, did you follow a procedurally fair way of resolving this? And that is spelled out in BELA.
Professor, thank you very much for your insights this afternoon. Hopefully this 90-day period will yield, or these engagements within that period will yield positive results. Thank you very much for joining us yet again. That's Professor Mary Metcalfe, Education Specialist.